And so some of those sorts of circumstances are where some combination of the standards that have been established by prior case law plus executive interpretations and any gaps filled by common law starts coming into play as the court starts weeding through these different complicated situations. But the vast majority of patent filings end up being like pretty open and shut as far as the conception piece goes. Non-obviousness, question about conception or something else?
Yeah, kind of. So like, can like a company or a group of people like apply for a patent, or does it always have to be one person?
Good question. So yes, they can. Patent rights accrue to an individual, but you can jointly file, like that can be multiple individuals. The company piece of this is interesting. Companies cannot file for patent law. Actually, I'm not sure. I do know that the way that usually is structured is that the company does not file for it, but rather that it's written into your contract. If you're like, working at Google or whatever, that anything that you come up with in the course of the work you're doing at Google, which is different from during the period of employment, right? What you do at home on your own time is a separate question, unless your contract explicitly says otherwise. But like, it's very common for there to be contract provisions that assign your inventorship and ownership rights to over any inventions there to the company. So it would still be your name on patent filing, but that would then be transferred to the company. Yeah. Other questions? Because the idea there being like companies can't conceive of the thing, right? So a company can't meet the conception requirement, but they can't own the thing produced. They can't have that monopoly. Like they can be, you can have entered into a legal arrangement with them in which you voluntarily signed away the right to enjoy the fruits of that monopoly to the company, even though technically it is you that has the inventorship right and not them. Does that make sense? Yeah.
Do patent protections end with death, or can they be like passed down generationally, or like given in a will to someone?
Do they? And you're saying like if you are the inventor and you have not given it away to anybody and you die before the patent term expires, what happens?
Or like, can you give it to someone like in your will or whatever? And then I guess also what happens if you die and it expires and you have it done.
I will say that this is, I do not know this for sure, but my guess, I would say I'm like 90 to 95% sure that the way that would work is you are still the listed inventor. It is still your patent. However, like with the company example, you can have assigned the right to kind of enjoy all the fruits of that to someone else. If you were to like not specify in your will who goes to or whatever, then that enters the realm of like estate law, and I have no idea how that works. Yeah.
So
No, sorry. Yeah.
I was just going to say it is an intellectual property right is like any other property right, and it is if somebody dies intestate, it would go into your estate, and then state property law would govern who gets that. It would generally be whoever your next of kin or your heir is if you have not assigned that right. But when you think about intellectual property rights, you should think about it very much like any other property right for the purposes of who gets it, who has access to it. So you can assign that right, or you can let the state assign that right.
Yeah.
similarly, say the person who conceived of the idea is unable to file, like if they died or disappeared, then can someone else file even if they didn't conceive of the idea, or is just
I don't know how that would work. I mean, the short answer is no. Like, you do have to meet the conception requirement, but I don't know what that means. I mean, I think that in practice, the way this would probably play out is just like you would be able to get away with fronting that you conceived of it. I don't know. That's a good question. Oh, yeah. Just use your hand.
Yeah. Are there legal provisions to like extend the limits of the patent?
What?
How like, to delay how long before the patent expires?
You're saying, are there ways of extending the patent period? Mostly, in theory, mostly no. In practice, there are all kinds of shenanigans that companies get up to do that. One is trying to find ways to patent things that are not actually novel, like we talked about earlier, by making them appear to be. Another is there are a variety of different schemes that make up over time. One that you may hear kind of kicked around this year is called pay for delay, which is a term used in the pharma context. Not actually tied to kind of the patentability of the thing directly, but rather the Hatch-Waxman Act establishes a sort of separate set of requirements / stipulations for when and how generics can be, like generic versions of a drug can be brought to market. And one of the ways in which companies will try to sort of artificially extend a monopoly or like delay that generic entry is sometimes they will file a patent for a thing that might win in court if challenged or might not, based on this like, is it novel type question. And then Hatch-Waxman establishes basically like a fast track way of just like, because we care a lot about generics getting to market and preventing pharmaceutical companies from getting away with shenanigans, there's sort of like a separate fast track provision for bringing challenges to those kinds of weak patents. Does that make sense? And so one thing that pharmaceutical companies will sometimes do is file this sort of like weaker patent, and if they initially get away with it and a company starts making moves to like start signaling that they're going to try and like use this fast track provision to challenge it, they will instead like negotiate directly with that company and be like, we will pay you a lot of money every year to keep not challenging our patent. Does that make sense? So there are a bunch of workarounds like that that are themselves in sort of like a legal gray area. And so one of the things, like this starts to bear on why this topic is timely and important, right? Because there are all these questions about, okay, we have a patent regime, in a lot of ways it's quite strong. But there are a variety of ways in which it might make sense to either make it stronger, strengthen enforcement or whatever, or alternatively to kind of weaken it and crack down on companies exploiting it in those various ways. In terms of being able to lawfully be like, I would like more time for this patent, please. Not as far as I'm aware. No.
And like while the patent is being filed, like while the same process, is it protected by the patent?
While it's being filed.
Like when it's being processed by the PTO?
What do you mean protected?
Processed. Like if the PTO is.
Yeah, but you said while it's being processed, is it being protected? Do you mean like do you have a patent?
Does the company have the monopoly?
Yeah, so if you were to, so this gets to the significance of the like first to file provision. There were other ways of dealing with this that we used previously, but now the way it works is like, you file for first, someone else tries to file for a similar patent, or engage in activity that infringes on that patent filing. The relevant question is like, what is the date on which you filed it, or whatever, not, and compared to when that activity is engaged in by other people and or companies, not what was the date on which you ultimately were granted the patent. Does that make sense? Yeah.
Can you refile or re-challenge a patent? Like, I know that there's no double jeopardy in court cases, but say you challenge a patent and then you lose that challenge. Can you challenge it again?
You're saying, oh, I mean, you can't bring the same suit again, but if you're saying there was like some other problem with the patent or whatever, then maybe it depends on the circumstances.
Understood.
Yeah.
If you have agreed to sign over your rights to.
Sorry, real quick. The reason I said maybe / depends to kind of, there is a relevant, a more broadly relevant like legal idea there worth being aware of, which is if it is a thing that should have properly been brought up in the course of that prior challenge, then the court is unlikely to be receptive to you later on being like, hey, please, I was bad at my job, let me do this again. Whereas if it's like a separate legal case or controversy, that's a different situation.
If you have agreed to sign over a patent to the company you work for like if you're currently like working for Google researching and you file a different patent that is separate from your work, are they entitled to the patent even if it is unrelated or represented by the work you've done with the company?
So it depends. It depends on the details of the contract that you entered and how it's phrased or worded. It depends on when and how you conceived of the thing. Did you employ any resources of your employer in the conceptual production of the thing, right? Like, was I working on my employer's computer when I was like doing all the work on this thing or not? So it gets murky and sort of depends. In many cases, the employer will try to say yes, and the employee obviously will try to say no. But it's very much case by case.
Follow up to that, if you conceive of an idea whilst working for a company that you have that agreement with, and then do not file a patent or release the information until after you have left the company, do they have right or like
Yeah,
the
that,
ability to stay whole on that?
that part in theory doesn't change the situation at all. Because the relevant question is when and how it was conceived of.
So it's the conception.
Yes.
So when AI inventions being patented, when AI updated the patent, like who gets to be the
Yeah, so the question was, what does that mean we do when AI comes up with something? And that is one of the start packet apps because that's a good question. We'll talk about that more when we get to the topic area breakdown. But there are many different possible answers to that question. It all makes some meta sense, no upsides, downsides. So we'll talk about it.
Is it possible for like two people to file a patent?
Is it possible to say it again?
Is file a joint patent with someone?
Yes.
And then kind of follow, is it possible for the court to say like one of those two parties can have a significant like
Yes.
stake in that even if they both agree?
Yeah. Yeah, you in theory cannot be an inventor. You can have ownership over the resultant patent, over the resultant property rights. And this kind of gets back to the thing we were talking about earlier about raising my assignment to a company, every stuff Danielle was saying about what happens with your estate after you die. But in terms of being listed as an inventor, in theory, only somebody, the only person who can initially receive that / be an inventor of a thing is the person who conceived of the thing. And it is, like Danielle gave the example earlier of the flip side of the 3-year-old, doing it after a 3-year-old thing, which is your 3-year-old comes up with something and you claim that you are one who, you then file on your own behalf. That's illegal, can't do that. Yeah.
Can you voluntarily end the patent period early, if you die and have the patent?
Yeah, you can do whatever, it's your, in the same way that if I go to the store and buy a sandwich or whatever, and give you the sandwich, I can do with it whatever I want.
Would you have to go to the government to release the information that you gave when you were filing?
To release, so the information is out there the moment you file.
So
That part does not wait till the end of the period. The only part that
people
waits,
know how to make.
Yep, they simply are not allowed to.
Okay.
Which is, again, from this point of view, a feature, not a bug. You want people to be stimulated by a set of ideas, but they can't copy the thing until later.
And can the government end your patent rating for some reason?
I mean, sure, yeah, the government can, I was gonna say do whatever they want, which isn't strictly true, but mostly true. The executive branch couldn't unilaterally be like, hey, you no longer have a patent. But the court could be like, this patent is unlawful or invalid for the same reasons. Or Congress could come along and be like, we're establishing this new statutory regime that governs how patents work in a given context.